Network. And welcome. You are listening to Black Talk Radio News with Scotty Reed. Tonight, we are speaking with Devontae Sanford, mother of wrongfully incarcerated teen Devontae Sanford, and Roberto Guzman of the Task Force to Free the Wrongfully Convicted. Welcome. I want to welcome you both back to the program.
Thank you.
I guess I'll start with you, Ms. Sanford. Concerning the prisoner abuse at Iona Correctional Facility, the last time we spoke to you on the program, you had read a letter from Devontae that stated that he was being abused by prisoners. Since that time, have you had an opportunity to talk to Devontae? Have you heard anything by phone or letter?
First, I want to just straighten that out. It wasn't by prisoners; it was by correction officers. And I haven't spoke to Devontae by phone, but I have got a letter from Devontae.
And did he mention if the abuse was still going on?
He just said the guys that he wrote about have backed away from him, and he had gave me some other numbers for some parents that he wanted me to contact because he told me that one of the guys was so severe beaten in there that the guy's mother needed to come up there as soon as possible or contact someone.
Now, Roberto, you can jump in here at any time. Now, I understand that both of you discovered in filing a complaint or trying to get relief for Devontae that there was an investigation going on with other prisoners alleging abuse.
Yes, that's the information we were told by the Legislative Ombudsman's Office when we called in the complaint about Devontae, that apparently there are some widespread abuses that have been going on at this prison, and they were there a week before we spoke with them about the abuses that Devontae was going through.
And so this is, as far as you know, still open investigation?
That is correct. And we left it with the Legislative Ombudsman's Office that we want the abuse to cease and desist on Eighth Amendment grounds, that we wanted Devontae, and as well as all the other prisoners, be treated with dignity. And more importantly, we were concerned for his health and well-being. We sent a cease and desist letter under Farmer versus Brennan to the warden. We made it clear that his mother was concerned for her son's well-being, and we did identify the abuses, the three officers, and thankfully, as Tamiko indicated, Devontae wrote her back and said that those officers have backed off and released for the time being, but we hope it stays that way. But we placed it in the Legislative Ombudsman's hands, and we made it clear to them that we intend to hold them fully responsible if any harm comes his way. If he denies the basics of any health, his health care needs, they be met, and we, more importantly, we want the abuse to stop.
Now, for those who are in different states or possibly different parts of the world, and this, in looking into this case, can you explain to us what is the Ombudsman's Office? What do they do? How do they fit into Michigan's legal system?
The Legislative Ombudsman's Office is a team of lawyers. They act as a watchdog. They were implemented here in Michigan in 1999, and their responsibility is specifically limited to investigating abuses at Michigan prisons. And this was in the wake of a the UN Human Rights Commission report in 99 or 2000 about widespread rape of women here in Michigan prisons. So this was a response to that. The legislature implemented the Legislative Ombudsman's Office, and again, that's what their responsibility is to investigate allegations of abuse and take remedial measures, and we hope it will work. So far, from the letter Devontae sent to Tamiko, it has worked. That's what we wanted for the abuse to stop.
Now, Ms. Sanford, another issue that was raised on the last time you spoke with me was that Devontae was saying that he could not have any visitation with his family because of demerits. Has that been addressed? Can you share any new news with that or about that with us?
No, it still stands. Devontae can't have visits from his family for 2 years, only with a lawyer.
Wow. Now, Mr. Guzman, I think me and you may have spoken through email about this. Isn't this possibly a violation of the human rights, different human rights, of course, that the United States has signed?
Well, I can't answer to that, but let me say this. It's certainly rising to the level of psychological torture to lock any prisoner up for 23 hours a day for 2 years. And while I admittedly don't understand the grounds for why Devontae is in solitary confinement, my understanding is more for his protection than punitive measures. But still, it's very repressive. It's very burdensome to lock someone under those conditions. He's being stimulated. Can't have physical contact with family visits. I don't even know if he's allowed on television. If you can imagine how tormenting this is to lock someone under these conditions. Now, they will probably say for protection or for some punitive measures, and my understanding is that at the evidentiary hearing this past summer, the prosecutor threw up the fact that, well, Devontae racked up dozens of misconduct tickets. Well, what she didn't tell the court was that it was because he was defending himself from bullies who were trying to rape him in prison. So they've been portraying him not only as a murderer with respect to these 4 killings in Runyon Street, but now they're making they put forth fraudulent image that he's a bully in prison. He needs to be punitively segregated. It made me fly off my chair when I heard that, because they didn't tell the court the truth. He's in isolation because of his youthfulness. They tried to rape him, and he's defending himself because his custodians turn a blind eye to it, and they're not going to defend him from being raped.
Oh, very, very serious, and I'm still waiting for some information from some people I have reached out to, but it is my belief that this is a violation of his human rights. I mean, you know, we know that prison isn't really for rehabilitating anyone. But let's just say, for the sake of argument, that that's the main purpose of our correctional facilities. I mean, to deny somebody visitation for any length of time with their family members, I think that would be, that would cause them to act out, and that will have a detrimental impact upon them.
Oh, you're certainly right, Scotty. I mean, that's one of the goals of the Michigan Department of Corrections. They say is to maintain familial ties with families and associates on the outside, so that the prisoner can be prepared to reintegrate back into society. And keep in mind, this year is not written in stone. This is what they're saying for now, but I've known them to go beyond that in other cases where they tell a prisoner you're confined to segregation for 1 year, and that prisoner has been in segregation for 3 or 4 years. But you're absolutely right. When you break a family tie like that, it's not rehabilitation. It only hardens the prisoner, makes him more bitter, and that it's just counterintuitive to psychologically torture someone like that.
Now, you mentioned the prosecutor's office. Now, you had sent in a Freedom of Information request to the Wayne County Prosecutor Office, which is led by Kim Worthy. We also wrote an article about it, which was published on Black Talk Radio Network, as well as ThyBlackMan.com. And you made the assertion that it was possible that they did not give you all of the DVDs of the 2 interrogations of Devontae, as Detroit police are required to do in an agreement with the prior case of wrongful conviction. And I mean, do you still stand by that assertion that possibly they didn't send you one of the DVDs, or is there something else that could be going on here?
I still stand by that assertion, but let me say this. The prosecutor says they only have one DVD, but there's no dispute. Even they don't disagree that there were 2 interviews 15 hours apart. Under the federal consent decree and the decree that the city entered into in 96 in the Eddie Lee Lloyd wrongful conviction case, you are absolutely right, Scotty, they were required to record every interview they had with Devontae. And the prosecutor sent me a request to recant that portion of my interview, saying that they were withholding DVDs. Maybe they're not, but they certainly know that there should have been more than one DVD of Devontae's 2 interviews, if not more interviews. So it's smoke bombs that they're dropping on me here, and I'm not going to recant that, because as I told the prosecutor's office, there should be at least 2 DVDs, and it was their job to go back to Detroit police and ask where's the first DVD.
Mm-hmm.
And they haven't responded to that, of course. So you got to stay caught up with them, because they do this to deliberately drop smoke bombs on you and make it sound like you don't know what you're talking about. But I have 2 statements from Devontae in front of me, one at 4 in the morning and the other 9:30 at night. Where's the DVD for the 4 o'clock in the morning interview? They haven't responded back to me. I'm not surprised by that.
So again, they're not disputing, and you have evidence that he was interviewed more than once. And as you stated, and can you restate that again, that the reasons why they are required to record every interview they do of a suspect in a serious crime, such as what Devontae was charged with?
Yes, Detroit police are required, when they are interviewing a witness or a suspect for a capital offense for which Devontae was being interrogated, to record that. That's under the federal consent decree and under the consent decree that the city signed with the federal government in response to the Eddie Lee Lloyd wrongful conviction in 96. But to say something to the federal consent decree, they were found to be in compliance in only, I think it was 33% of the terms of that federal consent decree. And I would not be surprised, other than Devontae's case, there's a lot of other cases where they have interrogated suspects and not properly recorded the interrogation like they were supposed to, in violation of the consent decree. So here's another thing about Devontae's case, that going back to the 4 o'clock in the morning interrogation, I suspect that between that 4 a.m. interview and the 9:30 p.m. interview that day, there were other interviews with Devontae where I understand that they took him to the scene of the crime. They showed him pictures of the dead bodies on the officer's digital camera. How come none of that was recorded? What's the DVDs with that? And you have to think that they did something improper, or there was some sort of misconduct in the police department that rose to the level of impropriety to prepare him to confess to the second interview at 9:30 that night. That one they did record. Why? Because the officer prepared a confess statement and had Devontae agree to it all.
Ms. Sanford, would you like to add anything?
No, he's correct.
Okay. Now, last Monday, there was a rally held for Devontae Sanford and Charles Jones. We reported on there. Both of you came on the program to discuss it. I'll go with you first, Ms. Sanford. Can you tell us, how did the rally go? Were you pleased with it? Do you feel like anything was accomplished?
Yes, I feel that the message did get across to Kim Worthy, but I'm still waiting on Kim Worthy to come to me and tell me that my son is guilty. She's hiding. Why are you hiding? What is you hiding for? What is you hiding for? Why is y'all all hiding behind this door when y'all took my son's freedom away from him?
The last time that I believe we were corresponding by email, Mr. Guzman, and you, well, it was actually reported in the Detroit Free Press that the prosecutor, Kim Worthy, agreed with Judge Sullivan's ruling, which denied Devontae a new trial. I mean, what do you have to say about that? I mean, knowing that the prosecutor office knows that Vincent Smothers has confessed to these crimes, they know that he said he doesn't know Devontae, that Devontae had nothing to do with the Runyon Street killings, and they also know that Vincent Smothers named his accomplice. I mean, what does that say about Kim Worthy?
Well, it doesn't surprise me that they stand by Judge Sullivan's decision, because his decision puts the final nail in the coffin of corruption. They don't have to worry about confessing error. Of course they're going to stand by Judge Sullivan's decision. It covers up the decision to help Detroit police cover up what happened in that interrogation room, before that interrogation room, when they took Devontae to the murder scene, when they took him around to the Coney Island, when they let him play with the officers, play on the officer's computer, when they showed him photos of the dead bodies, when they did all these leading things to a 14-year-old mentally disabled kid to get him to finally confess. Of course they're going to stand by Judge Sullivan's decision. They don't want to confess error here, that they sent a 14-year-old kid to prison, and of course they stand by Judge Sullivan's decision, because they don't have to worry about Vincent Smothers haunting them anymore. But hopefully that the Court of Appeals will see all this, reverse Judge Sullivan's decision, and I'm optimistic that they're going to agree that he abused his discretion and tell him the only way you could make a ruling as to whether Vincent Smothers' confession was reliable or not is to put him on the witness stand.
Which he denied, which he wouldn't allow Vincent Smothers. And I think we should point out that Vincent Smothers, at this hearing, was prepared to testify with no immunity deal. He wasn't seeking anything but to tell the truth from the information that I've gathered.
Good point, Scotty, and that's what was missing from Judge Sullivan's 29-page opinion. He made much of the fact that Vincent Smothers had two prior opportunities to take the witness stand and refuse, but why should I give him a third chance? That was basically Judge Sullivan's attitude. So give him a third chance, because what's different about this third opportunity, like you said, Scotty, is that he was willing to take the witness stand without a grant of immunity. He was willing to face a life without parole sentence by getting up there, atoning for the fact that his kid is doing time for 4 murders that Smothers committed. And what Judge Sullivan conspicuously failed to point out in his opinion was that the first 2 times that Smothers refused to take the witness stand was because the prosecutor would not offer him a grant of immunity. Well, why won't you offer him a grant of immunity? Because you know you sent Devontae to prison for 4 murders he did not commit. Let's face it. That's what this is all about. This judge abused his discretion. I don't care if it was the 6th or the 7th opportunity for Smothers to get on that witness stand, but that's what's so significantly different about his willingness to testify this time. He said, to hell with immunity. I cannot live with the fact that this kid is doing time for something he didn't do, because it is hell in here. It is a living hell in here in prison. So he wants to atone for the fact that Devontae is doing time for something he didn't do. Judge Sullivan should have let him get on that witness stand.
Ms. Sanford, I would like to give you the last word in this interview. Everything that we've discussed here, what would you want the listener to most take away from this interview?
Basically, I just want everybody to know that Devontae is innocent. I just want the truth to prevail. I just want him to get justice. You know, there's too much evidence out here for the judge and the prosecutor to be doing Devontae the way he's doing him. So just my philosophy, I just always felt that they scared of Smothers, and they covering up for Smothers, and if Smothers open his mouth, that it's going to be a domino effect to Detroit police and the prosecutor. I just feel that we think that it's this little fish in the sea, but we really actually dealing with sharks in the sea. This case is deeper than what people was looking at, and we need people to stand up and support us, pray for us, and even to Right, Devontae. Keep Devontae uplifted. He don't get, he don't know what we're out here doing, pushing for him, giving rallies and giving radio interviews. This doesn't mean nothing to Devontae like it means something to me. It means the world to me. I'm just asking everybody just to watch Devontae. Keep him uplifted. Let him know that he's not fighting this and going through this alone, that he got people that care for him. Let him not give up his hope. He has been on suicide watch before, and just a lot of things that he's going through with the blind dog. Can't see me for 2 years. Is not able to talk to me. The judge denied his appeal. You got to imagine what this person, this child, my son, is really going through. What goes through his mind daily, night and day, when he lay down, when he open his eyes. We can't say what he's going through because we don't know what he thinks. We can just assume what he's going through. I know the pain that I'm going through as his mother, and I'm still out here with my freedom, but fighting for him is what saddens me because I'm fighting with everything I got, and they still doing what they doing. So we got to put ourselves in Devontae's shoes. This boy been gone for 5 years.
Well,
for a crime he's still to commit.
Well, certainly it's a case that we intend to keep following, and I especially would like to commend Mr. Guzman for the work that he's been doing on this case, and for keeping me informed and keeping me in the loop. And going forward, I just ask that you both just keep us up to date, and we'll do our best to get the information out to the people.
We certainly appreciate you, guys. Thank you so much.
Thank you both.